Yes, hello. I'm going to start by talking about how translator contracts relate to the underlying contract of in the original work, because this is a topic which comes up a lot. And I think if you grasp this point, then a lot of the other issues in your negotiations will suddenly become quite a lot clearer. So the key thing to bear in mind at the start of the process is to remember that the original work and the translation are each entitled to copyright. So the copyright in the translation belongs to the translator, and it exists in addition to, rather than instead of, the copyright in the original work. So as the translator, the copyright in your translation is yours until you decide to give it away to somebody else. And obviously, in this context, we're talking about the rights that you would grant to a publisher to publish your translation. And if a publisher is going to publish your translation, it needs two sets of rights. So the publisher has to have the right to publish the translation of the original work. So if the publisher, for example, is publishing a novel originally written in French, it needs to have bought the English language rights from the original French a publisher or the author or the agent or whoever holds those rights. But the publisher also has to have the rights in your translation. A publisher has to have both sets of rights. So that's really important to bear in mind, because I think authors sometimes in particular don't always grasp this point. But both those sets of rights are needed. And in the UK, I'm not sure if it's slightly different in the US, but in the UK, you don't actually have to register your copyright. As I say, it's yours until you choose to give it away. Now, assuming that the publisher has bought both those sets of rights, the rights that the publisher will ask you to grant in your contract should mirror the rights that it holds in the original work. So, for example, if the publisher has got the rights to publish the original work in what in the UK we traditionally call print and volume form, then that means print and ebook. It might sometimes include audio, although we would always argue that audio rights ought to be dealt with separately. But it wouldn't, for example, include a dramatization rights. If you see the words "and in all media" in your contracts, then that should set the alarm bells ringing, because that includes, as it says, all media, and that includes the right normally to adapt and dramatize. And I do think it's worth stressing that publishers can be very general and quite poor in how they word their grants of rights. Even in my work as a contracts advisor at the SOA, we can see the same wording in a rights clause, and one publisher will swear that it means a one thing, and another publisher will argue that it means the opposite. So, it's important that you shouldn't be afraid to go back to the publisher and ask exactly what rights they are taking. And at that point, I will come back a bit later on some of the implications on subsidiary rights with those rights. But at the moment, I'll hand over to Julia, who's going to talk about advances, fees, and royalties.
Thank you, Catherine, for getting us going and giving me some time to wake up. One point on the US side is that most of our contracts tend to include a clause that stipulates that the publisher should register the copyright of the work of the translation in your name within a certain period. I was recently negotiating a contract that said the word promptly, and I asked that to be defined, which is something that is very helpful to do in negotiating contracts. When there's a word, you know, depending who you are, promptly means something else. Promptness for a Brazilian is one thing, and promptness for a British person is something completely different. So it's good to define those terms. But advances and fees. Until recently, the kinds of payments that translators have received have sort of mirrored the way authors receive payment, which is an advance against royalties. Apologize to all of those who already know what this means, but essentially what that means is that the publisher will advance a payment to you, and then you only really see royalties after that advance has earned out, i.e. after the royalties, your percentage of royalties makes up the $2,000 advance that you were paid, for example, to pull a number out of a hat. More and more, we're seeing and encouraging translators to ask for a fee. And the difference in those words is important, because a fee is a one-off payment against which you do not have to earn royalties. So sometimes a fee can be attached to a work for hire agreement, which is a very bad agreement that you do not want to sign, which essentially hands over your copyright and all rights in the work to the publisher. And oftentimes does not come with royalties. Sometimes you can see a fee in those cases. But you can also see a fee in a more traditional contract, which means you get the lump sum of, say, $2,000 again, and then you start earning royalties from the first sale of the book. So you don't actually have to wait 15, 20 years for your 1.5% royalties to make up the $2,000 advance that you were given. And oftentimes the advance is much higher than $2,000. So that difference is important to keep in mind. And I'm not sure if I'm allowed to urge, but as I'm here with several hats on. I'm a translator. I also I'm on the Council of the Authors Guild, sort of trying to advocate for translators' rights. And I also work at a small publisher. But as a translator, I urge other translators to try to get a fee with a royalty after that. When you do have an advanced structure, keep in mind that because it's modeled after a traditional author agreement, the author doesn't only earn out their advance with a higher royalty, they also have other payments that go into this pot. And that is something that Catherine will touch on later, but essentially subsidiary rights payments. So if the publisher sells audio rights, then the money that they get for the audio rights, a percentage of that goes into the pot that helps the author earn out their advance. Likewise, in the case of a UK publisher, the rights for the US. So say a small press in the UK has the rights for a book, and then they sublicense the US rights to a US publisher, and that publisher pays the UK publisher some money for the translation. Usually the split, as I know it, is 60%. The US publishers pay 60% and the UK publishers pay 40% because of the size of the market. That means that the advance that they covered has already been, compensated by 60%. That means they've only actually had to pay 40% of the advance out of pocket. But if you're not getting subsidiary rights, you're still earning out the 100% that you were paid, even though the publisher has only paid you 40%. So that's something to keep in mind. The other thing to keep in mind is, as you know, in the UK, there are loads of, this is much, it's either completely rare in the US or like totally doesn't happen in the US, or very rare, but there's funding. In the UK, there's funding that isn't attached to national bodies. So like there's funding that isn't attached to just Spanish authors. For example, there's the English Pen, which funds up to a certain percentage, like a certain amount of money. And so if the publisher is receiving, say, 100% of funding for their translation, and you're still earning out from your advance, then the publisher has, in a way, made money on that translation, and you still have to do the work of, well, you don't have to do the work, but the book has to do the work of selling enough for you to see royalties. So you can, when keeping that in mind, you can ask either for royalties to be triggered earlier if the publisher receives funding, or for your fee to be higher if the publisher receives funding. There's a lot of room for you to be creative in that respect. And then an important thing that comes with with payment is when you receive your payment. For author contracts, it can be split into many different pieces. So sometimes it's split into 4 payments, one payment being on signature, the next on delivery and acceptance, the next on first publication, and the last is on publication of the sort of hardcover publication, then publication of the paperback copy. Thankfully, translator advances and fees tend to be split into 2 most of the time. Sometimes they're split into more, but again, I would encourage you not to well, think of whether you can actually financially accept that. But it tends to be signature and delivery. But as many things, as you have to do with many things in a contract, you have to define delivery and acceptance. The industry jargon is DNA. The end being the ampersand, not N like our DNA. And so that's quite broad. There is delivery and acceptance. But what does acceptance mean? As we all know, there are several stages in a translation after the translation has been delivered to the publisher. You receive a first round of edits, maybe you receive a second round of edits, then you have copy edits, proofs, then it's typeset, then you look at the proofs again, etc. And at what point in this process has it been accepted? Some publishers will off the bat say that it's on delivery and they pay you in good faith that you've done a good job, or like they, skim it, assume everything is fine, and then pay you. Other times acceptance can be once it's been through one round of edits, so that both parties know that they're on the same page. Sometimes a publisher will define acceptance as proof stage. So like once the book has been typeset, again, because you have no control over the timing, it might be wary of accepting something that is so late in the process. The book is typeset not long before it's actually published. So, you could be waiting 6-7 months or more to receive payment for a book you delivered in December, say, and you're still waiting for payment in September. So those are some things to keep in mind. And then for royalties, our note says that we're to talk about industry standard in UK and US. I actually don't know very much about royalties on the UK side because I mostly deal with US publishers, and all of my information about contracts comes from working at a US agency. But we know that it's standard for the translator's royalties to come out of the author's share, which is not, I'm not saying it's necessarily the right way to go about things, but this is how it's done right now. So it's good to know what the author's share is. So in the US, the standard is for hardcover, 10% of the list price, which is the price on the jacket. So you can actually calculate this. You don't have to try to figure out like mysterious costs that go into publishing a book. It's 10% of the price that they're selling the book for. And you also don't have to worry about discounts. Like, how deeply is Amazon going to discount this book? Who knows? So 10% to 5,000 sales, 12.5% to 12,000, 10,000, 12,000. I can't remember now, but it's 15% after 15,000 copies, I think. I think it goes up in it's 5, 10, and 15. I can't remember. Sorry, I need more coffee. But, you know, there's an escalator. And you can, if you Google this, you'll probably figure it out. But I can't talk and Google at the same time. And then for paperback, it's 7.5% list. And there is generally no escalation, though sometimes, you know, if you're Salman Rushdie or Martin Amis or Zadie Smith, maybe you can work out some sort of royalty escalator. And then for the industry standard for ebook is 25% net. That is a cost that's a bit more difficult to figure out because you don't exactly know what the publisher net is, like what the publisher receives. So all of your royalties are going to come from there. For now, I have yet to see an escalating royalty for translators, which does not mean it shouldn't exist. I just haven't encountered one. I would imagine that an escalator would only happen on hardcover copies but we usually sort of bundle both of them together and ask for like 1.5 or 2% on all physical copies and 5% net on ebook. Yeah, I don't know if this is different, how different it is in the UK. Maybe Catherine can jump in and stop you from rambling.
Yeah. No, not at all. In fact, I was just going to say that I thought perhaps that escalators were more common in the US than they are in the UK, which just goes to show perhaps how useful it is to have these kind of conversations. Yeah, escalators do happen on translation contracts. In my experience, they don't tend to have that many steps involved on the escalator, if I can use that analogy. I tend to see things where a royalty will kick in at a certain point. It could be around 3,000 or 4,000 copies sold. For example, it could be more, in which case it's probably not really worth having the royalty because it's quite unlikely. It could be less. It could very occasionally be tied to exactly the same threshold as the author's royalty will kick in. I've seen that occasionally, but you need a very good and transparent publisher to do that. I do think an escalator is worth asking for, particularly in a case if a publisher has said to you point blank that no royalty is available, and that's normally because the translator has been forgotten about either on purpose or accidentally in the head contract, which is between the publisher and the original author, or more likely the author's agent. I'll come on to that a bit later with subsidiary rights. So I think escalators are there, but I think they're likely really as a kind of a halfway house between a fee and an advance, that after sales hit a certain point, then you will get something. If you want some more specific details, I think the Authors Guild Translators model contract does have some specific percentages and suggestions for what they would recommend in contracts. From the UK, we're not as specific as that, simply because we feel there are so many other factors involved. It's really hard to be specific. But where you are getting a royalty, in theory, as Julia says, a translator's share should come out of the author share, and that's in the ratio of 4:1, or if you prefer to see it in percentages, of 80% to the author and 20% to the translator. So, for example, on a standard 10% royalty, then the translator would get 2% and the author would get 8%. And on the 25% royalty for ebooks, which is also the same in the UK, then we would expect the translator to get 5%. And as Julius already explained very well about the difference between a net receipts and list price, in the UK, rather than the phrase a list price, you'll usually see the phrase RRP used, or the recommended retail price. So I hope that's helpful. Is there anything else, Julia, to add on that?
I think that's all for royalties, and now we move on to subsidiary rights.
Yes. Subsidiary rights. So what are subsidiary rights? Well, put very simply, they're the rights that are granted to a third party to exercise on behalf of the publisher. Actually, having read that out, I'm not sure if I have phrased that simply, but hopefully all will become clear. So subsidiary rights are those granted to the publisher by the translator, which the publisher doesn't exercise on its own, but it allows someone else, such as a foreign publisher or perhaps an ebook publisher, to exercise on its behalf. A translation publishing contract is an agreement between a translator and a publisher, and only the publisher can exercise the rights granted in it, unless additional specific language gives the publisher the authority to allow someone else to exercise the publisher's rights in its place. So to try and put that into practical terms, in the first grants of rights clause, which ought to be the first thing that you see in any contract, you will normally be granting the right to print, publish, and sell the translation. That is a primary right. But your contract will also give the publisher the right to license other rights to a third party. And those are what we call subsidiary rights. The most obvious example of those is dramatization rights. So basically, the primary rights are the things which the publisher directly controls in their relationship with you. So the publisher is printing its own editions, it's selling its own editions, all of those are within their control. And that's what's been directly agreed between you and the publisher. But the subsidiary rights are one step removed. They're rights that that the publisher is granting to other people to do things with. So an example of that in more detail, Julia's already spoken about deals between UK and US publishers. So a publisher will probably license your translation to another publisher to print. So for example, there are English language rights, and the most usual thing would be for a US publisher to license a UK English language rights, or vice versa. The other example that we see a lot is dramatization rights, but it's very unlikely that a publisher will actually have rights such as dramatization rights. And normally those are quite tightly controlled by the original rights holder. And that's why it's really important to try and ensure where you can that, that the rights that you grant to the publisher are the same as those rights which the publisher has in the original work. So if you grant your dramatization rights to the publisher, even though the publisher doesn't have the rights in the original, the publisher can then exercise those rights in your dramatization on your behalf. Now, if you've got a book that suddenly has the potential to turn into a Netflix bestseller, you're cutting yourself off from quite a considerable income stream there. And that's why we always recommend that, if at all possible, you hold on to dramatization rights. And I think it's worth saying at this point, don't be afraid to ask publishers questions about their rights. Sometimes publishers will push back and say, oh, you know, this is confidential financial information. It doesn't affect you. It's not relevant. It is. it's your book, it's your contract. And it's really important that you feel comfortable in asking the publisher as much as possible, what rights do they have, and how do they intend to exploit them? It's no good arguing over some rights if you discover that the publisher A doesn't have them, or B doesn't even intend to use them. If they aren't going to produce an audio book, it's not worth arguing about what the audio rights income is going to be. So I really would stress to everyone that you should feel confident in asking publishers those kind of questions. So to go back to where I started about 3 hours ago, in terms of subsidiary rights, there can be quite a major financial difference for you, depending on whether the publisher has the same rights in your translation and in the original work. If the publisher's got the rights in the original work and your translation, and they're going to sell those, for example, to a US publisher, then the money that they receive, as Julia's explained, there'll be a proportion that will come into the publisher. Then there will be a proportion to be shared between the author and the translator. But if the publisher only has the rights in your translation, doesn't have the rights in the original work, then the publisher who wants to publish your translation in the US will have to get those rights from somewhere else, normally the original rights holder, which means that all the publisher is doing is selling that person your translation. And we would argue really strongly that all they're doing then is effectively acting as agent, because they're not doing anything else. The author's not involved either. So you should get a much higher share of the income. Now, in practice, that doesn't necessarily happen, but that doesn't undermine the point that it's really important that you should ask for this. And again, it's so important to understand the rights that you have and the implications of those rights and what happens when you grant them. Julia, is there anything specific? I'll mention relay rights here, which I think it's really important for people to hold on to. Those are the rights if someone else decides to use your English language translation as the basis for a translation into a third language. For example, if somebody is translating from Vietnamese into Finnish, they're unlikely to have both languages, though it would be lovely if they do. So English would often be used as the third party there. So the English translation would be used as a bridge, if you like, between the Vietnamese and the Finnish. Now, in those instances, I would really recommend that you hold on to your rights, partly for financial reasons, not a huge amount of money, perhaps a couple of $100. Although I know some translators are currently successfully negotiating for a percentage of the sale of the rights rather than a flat fee. So that's something else perhaps to consider. But also because it's about other control of your work. If you're in control of your relay rights, then you know how your work's being used, and you're not suddenly going to go into an airport and see that your translation has been used as the basis for somebody else's work and you didn't know anything about it. And that's a real example. I know, more than one instance where that's happened. So always hold on to those rights. And if you are interested, a blatant plug here, the SOA has just updated its relay a translation guide, and I'm quite happy to send a free copy to anybody who's here on this talk if you'd like one. So that's another issue to consider. I think I've said more than enough about that. We've talked a lot about the money side of things. So perhaps as a change of pace, we'll talk a bit more now about the importance of editorial approval and consultation. Julia?
Yes. First, I'm going to actually drop a link to the Authors Guild model contract, which is available for free. You don't have to be a member of the Authors Guild, even though if you are in the US, I'm a member of both the SOA and the Authors Guild, just because I think the work being done is quite important. But the Authors Guild, like the SOA, has people who can review and vet your contracts and tell you what you should be asking for that you haven't already, or what you should be pushing against that you haven't, pushing back against that you haven't already. I send my contracts there because sometimes I just don't have the bandwidth to look very closely at an agreement or the time. And I learn something new every day. I think just one small thing to add to subsidiary rights is that you can do two things. You can hold on to your rights, which means that you control them completely. But you can also, if you can't hold on to your rights, ask for a percentage of the income, which is difficult, but sometimes happens. So to give some figures that I've seen, these vary wildly, but sometimes for US sales, I think they're called sublicensed to other territories. I don't actually know the exact wording. I should know, but again, it's early. You can see on the author side, it can be anywhere from like a 60-40 split in favor of the author, which means that the author gets 60% of that and the publisher gets 40%, all the way to like 90-10, but it's more commonly around 75-25 and 80-20. So you're essentially asking for a little slice of that if there's a sale, a little slice of usually the publisher side. Well, no, usually the author side, sorry. So something to keep in mind also for audio. Audio is interesting because audio can be a royalty if the publisher has the capacity to produce an audio themselves, but it can also be a subsidiary right, which is much more common for small presses because they don't produce their own audiobooks. They sublicense them to an audiobook publisher. And everyone's listening to audio these days. It's one of those rights that 5 years ago, we weren't thinking about as much as we were now. We are now. But anyway, so we started with the money because we all need to survive, right? But you also, it's also important to, I guess this sort of ties in a little bit to delivery and acceptance. We're going to talk about editorial approval and consultation. The way it ties into delivery and acceptance is that sometimes the acceptability of a work has to be defined. So like, what does the publisher mean when they say the translation has to be editorial acceptable? Or I think Catherine will have a sense of like the range of terms used. At the Authors Guild, our language says that it has to be of the same quality as the sample provided by the translator to the publisher before they were hired for the translation, which doesn't always happen, but sometimes happens. That way you have something tangible to actually refer back to. If they suddenly say, well, this isn't acceptable, by what, parameters are you judging the fact that it's not acceptable as a translation? So that's one aspect. And then, we're all, when we create a translation, we're all quite scared of what comes, trepidatious about what comes next. This is work that we've put a lot of energy into, and we have, a creative vision of what it is, I suppose. And so there should be a clause that at least gives you editorial consultations, which means that any of the edits that the publisher makes to your translation need to be sent to you so that you see it. That's like the sort of basic. They have to send you the edits they make to your work, because at the end of the day, your name is attached to this, right? So you want to make sure that, they're not, well, one example that comes to me, when I wasn't sent copy edits, and only received the typeset pages. And this book is set in Latin America, where we all say ciao, right? And the copy editor had changed CHAU, which I kept in a few times, to CIAO, which is the Italian ciao. And if I hadn't been sent this, then it would have been this weird disconnect in the text that wouldn't make sense. I would have felt embarrassed. I did feel embarrassed for the copy editor. But anyway, the step above consultation is editorial approval, which means that you have to say, these edits are great before anything moves forward. Oftentimes there's language that says not to be unreasonably withheld or denied, or, you know, to give the, I mean, it's worth remembering that when you're negotiating, all parties are trying to protect their best interests. And oftentimes the publishers aren't these awful, you know, moguls who are like just trying to steal rights because they can, you know, they're trying to protect their business, and you as a freelancer are your own business, and you have to protect that as well. So I think that's all I have on the editorial side, Catherine, unless you wanted to add something.
No, it's very similar here. I mean, our recommended wording is the publishers shall not make any alteration to the translation without the consent of the translator. Such consent are not to be unreasonably withheld. And similarly, our language talks about style and quality, but you may see strange things in a contract about a faithful and accurate translation. Well, how do you define accurate and how do you define faithful? I think perhaps something that is worth bearing in mind if you are concerned is not only to let them have a sample of your work, but to do a sample edit of an early chapter. I think that can be worthwhile as well. And then if there are any issues, you and the publisher can resolve those at an early stage. The other thing, just very quickly to be aware of, is to double check who has approval. Normally it's the publisher who's commissioning you. Sometimes it can be the author. If it is the author, and particularly if it's an author whose grasp of English is not actually quite as good as they think it can be really problematic. So find out right at the beginning who has the right of approval. If it is the author, it's extra important to make sure that you work with the publisher to agree on what is acceptable, and you can put wording in your contract to ensure that you are paid, even if the author has a complete hissy fit and decides that, you know, that your translation is awful. Those things are really important.